Okay, well, we're going to start. It's slightly odd speaking into the void. I'm just hoping that you can all hear me. I've unmuted myself, at least according to my screen I have, so I hope you can all hear. Welcome to everybody. It's very nice to see you, or at least see your names on a list, and gathering momentum as we have approached 11 AM. Just a couple of points before we get started with this webinar on secondary victim claims. First of all, questions. We've received a number of questions already, and we anticipate that there may be one or two more as we go along. If we have time at the end, what we're going to do is try and answer the questions that we've already received. And if you have a question as we go along, could you please use the Q&A tab, because we don't think we'll be able to answer those questions as we go along. We've got too many buttons to press, and Laura's the only one who's got control of the slides. So we think that could be a recipe for disaster if we try and deal with them actually on the hoof. But if you use the Q&A tab, then we'll know who you are and we'll know your email address, and we can respond to any queries after we finish the webinar as soon as we possibly can. The next thing is, please bear with us if we have internet problems. It can happen in even the most high circumstances, if I can put it that way, because those of you who watched Nick Bowen QC in the Supreme Court in the case of Henderson against Dorset Healthcare recently will have seen him saying to Lord Reed, "I'm so sorry, my lord, I couldn't hear you because you sounded like a Dalek." So if either of us sounds like a Dalek, then I'm very sorry, but perhaps you could just let us know with a chat note, or perhaps also with the Q&A, and we'll see what we can do. As Laura is the only person with control of the slides, you're going to be hearing a lot from me of next slide, please, Laura. One other point, I think you're probably all muted anyway, automatically, but if you're not, I think you should be, if that's all right, because that should help the sound quality. And so I don't forget, because I've been asked to mention this at the end of the webinar, I'm going to do it now. This is a quick advert for next week's webinar. Same time, same place. Russell Cox and Connor Kennedy will be discussing resulting trusts, constructive trusts, and Tolata claims. Me neither. I'm reliably informed it stands for the Trusts of Land and Appointment of Trustees Act 1996. So that's next Thursday's appointment, 11 AM, for your diaries. So let's get cracking. Next slide, please, Laura, our introduction slide. There we are. Okay, so we're talking to you today about secondary victim claims. So secondary victim claims, obviously claims by people for damages for psychiatric illness when they witness a horrific and shocking event rather than are participating in it. This whole area is complex and controversial. There have been 5 House of Lords cases between 1942 and 1999. For the quizzers amongst you want to know what they are. Borhill and Young, 1943. McLaughlin and O'Brien, 1983. Alcock and the Chief Constable of South Yorkshire, 1992, the first of the Hillsborough cases. Page and Smith, 1996. White and the Chief Constable of South Yorkshire, 1999. I'll give you the full reference because we haven't given it to you. It's 1999 2AC 455. That's the second of the Hillsborough cases. The 2 other cases involving claims for psychiatric illness and tortious responsibility, Grey and Thames Trains, and the current one in the Supreme Court, Henderson and Dorset Healthcare. As you'll see from the introductory slide, what we're talking about here is something that's been described as a patchwork quilt of distinctions, as Lord Hoffman said in White, more or less arbitrary conditions which a plaintiff had to satisfy, which were intended to keep liability within what was regarded as acceptable bounds. And I'm going to spend a little bit of time talking to you about how these claims came into being. So how did we get to where we are now? And I think what we're going to see is that ultimately what we're talking about here is judge-made law for practical purposes. And I think understanding how that arises, the history of it and the context of it, may be of assistance if you come across facts in the future which you find difficult to judge whether or not they fall on one side or the other side of the current line. I think it's only with an understanding of the history and context that one is able to make a sensible judgment as to what would actually happen on a new set of facts. The latest patch on the quilt, as we've described it, Poole and Royal Wolverhampton NHS Trust, that's Laura's case, which she's going to deal with in more detail later. It involves the tricky concept of what is an event, which is the sort of question that lawyers and philosophers get excited about, but not many others do. So could we have the next slide, please, Laura? I'm just going to explain what we're going to be talking about today. The first section, which I'm going to be dealing with, is primary or secondary victim. We just want to look at the history, and we want to look at what it means to be a primary or a secondary victim and the consequences if you're one or the other. We think the history and context is important, as I've already said. As far as the other control mechanisms are concerned, the control mechanisms, we're going to deal with a number of those quite quickly. So there are going to be two main focuses of today's talk. One is the history and context and primary or secondary victims, so section 1. We'll skip through the other control mechanisms quite quickly, apart from the bullet point 3 under section 2, proximity in time and space to the event. Laura will spend some time on that. We've set out the control mechanisms in section 2. You'll see there are 4 of them. They're well known. Under section 3, bullet 1, what a claimant has to prove, I think we could probably add another 2. Secondary victims have to prove that they suffered a recognised psychiatric illness. That is a hurdle they have to overcome. They also have to show that they suffered that illness as a result of the sudden appreciation of a shocking and horrifying event, and not something that came upon them gradually. Those 2 additional, as it were, control mechanisms will be dealt with by Laura, who's going to deal with that section on causation. So I've been talking about the history and why it's important. So could we have the next slide, please, Laura, because I want to talk about the early days and how this all started. 3 cases, 1901, 1925 and 1943. All of them involved pregnant women and the physical manifestations of shock. The reason, I'm going to say it again, why we think it's necessary to look at the history is that it's important to recognise that the control mechanisms are really judge-made law based on policy considerations. And the way in which they've been dressed up is under the broad umbrella heading of proximity. As I think I've already said, many of the questions about what would happen if need to be considered with this in mind. Which side of the line will a case fall? Another thing to note about these early cases is that they all involved shock which caused a physical change. So in other words, an impact to the mind that caused physical changes to the body. And until really Page and Smith, even in McLaughlin and O'Brien in 1983, that appeared to be something that was a requirement for these claims. But I think that has now evaporated as knowledge of psychiatric illness and medical science and so forth has advanced. Let's just take a quick canter through these early cases. So 1901, Dulieu and White, a horse carriage was driven into a pub. There was a barmaid who was pregnant who suffered shock. She became ill and gave birth prematurely. And here's something that I just wanted to tell you, not because I think it's funny, although it's certainly curious, but because I think it illustrates something about these cases. The claim in 1901 alleged that her child, the pregnant barmaid's child, was affected. And I quote, "In consequence of the shock sustained by the plaintiff, the said child was born an idiot." Now, what I think is interesting about that is that in 1901, they were using the term shock and nervous shock. So our language has not changed for these claims since 1901, whereas in another context, the said child was born an idiot, it clearly has changed. I'm not sure what idiot means. I presume some sort of disability or brain injury. That claim, incidentally, in that case was not pursued. The defendant argued in the case that there was no claim if there was no physical injury. The judge, Kennedy J, agreed to this extent there was no claim for mere mental pain, but the claim was allowed to proceed on the basis that the shock operates through parts of the physical organism to produce bodily illness. In other words, shock causes physical symptoms. Kennedy said that these cases can only be successful if they arise through fear of immediate physical injury to oneself and not others. So in other words, an early control mechanism for psychiatric injury claims, you have to be in fear for yourself, not others. Hambrook and Stokes took the law on. It was really the first secondary victim claim. An unsecured lorry ran down a street towards a pregnant woman. She saw the lorry as it came round a bend, and she knew that it must have hit or passed very close to her 3 children, who were now out of sight around the bend. She'd left them there a few moments earlier. She was not in any danger herself. She was easily able to get out of the way of the careering lorry, but she was terrified for her children, told by a bystander that a child matching the description of her daughter had been seriously injured. She later saw her daughter in hospital, serious injuries, The shock caused a hemorrhage, which led to an operation to remove a dead fetus. She too, I should have said, was pregnant. And a few days later, the mother died. And the Court of Appeal in Hambrook disapproved Kennedy's stipulation in Duluth that you needed to be in fear for yourself. And this was, as I said, the first secondary victim claim. There's no difference, the Court of Appeal said, between fear for oneself and fear for loved ones. And this seems to be essentially a policy consideration. Why should the law allow one claim, but not the other? But the Court of Appeal did say there should be no recovery for damages as a result of what you were told rather than what you saw with your own eyes. In Borehill and Young, which is known as, for some reason, the Edinburgh fishwife case, a pregnant woman heard but didn't see a motorcycle accident 45 feet away from her. The cyclist was killed. Plaintiff later saw blood on the road. She had no fear of bodily injury to herself, but suffered shock, and that later resulted in the stillbirth of the child. The House of Lords held there was no claim, it was not within the reasonable contemplation of the parties, i.e. the motorcyclist who died. It wasn't foreseeable to the cyclist in these particular circumstances, and the court looked at what those particular circumstances were, what he could see, what was in his field of vision, that a bystander might be injured by shock if he failed to exercise due care. And there was some disapproval of Hambrook, where Hambrook said that loved ones could claim. So that is how the law stood until the birth of the control mechanisms with McLaughlin and O'Brien. So can we have the next slide, please, Laura? So we're now in 1983. The plaintiff's husband and 3 children were injured in a road traffic accident. This is McLaughlin. The plaintiff was at home 2 miles away. She was taken by a neighbour to hospital. There she discovered that her youngest daughter had been killed and that the other members of her family had severe injuries. The judge held there was no claim because it was not reasonably foreseeable. The Court of Appeal disagreed, saying it was reasonably foreseeable, but dismissed the claim on the basis that policy reasons meant that she should not recover. The House of Lords decided that policy reasons were no bar. Lord Scarman said that they were not justiciable and that only legislation could prevent a claim that was otherwise consistent with common law principle. Lord Wilberforce, as I've mentioned before, maintained this idea, if that's the right way of putting it, that an effect on the mind must also produce an effect on the physical body. He said, whatever is unknown about the mind-body relationship, and the area of ignorance seems to expand with that of knowledge, he accepted that severe physical damage to the body may be caused by impact on the mind. But he recognised that the courts would need to put some sort of brake on the claims. And this was the first genesis of the control mechanisms. Lord Wilberforce identified 3 elements. The class of persons who could claim close ties of love and affection. The proximity of such persons to the accident. They needed to be close in time and space to the accident or the immediate aftermath. And third, the means by which shock caused injury. Not communication by a third party, it had to be direct perception. Talking of perception, Lord Wilberforce mentioned at page 423 of the reported judgment that seeing an accident on television might be something that the courts had to consider at a later stage. And he was right about that, as we're about to see. So whilst the guiding principle had previously been foreseeability, we now have in place from 1983 the control mechanisms which were explained and refined in Alcock, which is the next case. This is a well-known case arising from the Hillsborough disaster. Relatives watching the television or hearing radio reports claimed damages. The case affirmed the control mechanisms identified by Lord Wilberforce and McLaughlin. First of all, the injuries must be reasonably foreseeable. There must be close ties of love and affection, closeness in time and space to the accident or the immediate aftermath, and direct perception. Seeing on television was not enough. And I'm just going to read you one passage of Lord Ackner's speech because it's important when we come to look at direct perception. He said, talking about television coverage of gruesome events, however, the defendant would also know of the code of ethics which the television authorities televising this event could be expected to follow, namely that they would not show pictures of suffering by recognisable individuals. Had they done so, Mr. Heitner accepted that this would have been a novus actus, breaking the chain of causation between the defendant's alleged breach of duty and the psychiatric illness. So pausing there, what Ben Heitner was apparently accepting was that because everybody knows that TV pictures are, as it were, censored and will not show gruesome details, had the TV done so, this would actually have broken the chain of causation and given a reason for the claim not being successful. Going on, as the defendant was reasonably entitled to expect to be the case, there were no such pictures. Although the television pictures certainly gave rise to feelings of the deepest anxiety and distress in the circumstances of this case, the simultaneous television broadcasts of what occurred cannot be equated with the sight or hearing of the event or its immediate aftermath. Lord Oliver was the first to use the terms primary and secondary victims. He said, broadly, claims divide into two categories, that is to say, those cases in which the injured plaintiff was involved, either immediately or immediately as a participant, and those in which the plaintiff was no more than a passive and unwilling witness of injury caused to others. He posed himself two broad questions in secondary victim claims. One was the injury reasonably foreseeable? Was there sufficient proximity? And all these other control mechanisms that we're looking at today come under that umbrella heading. Was there sufficient proximity? Lord Oliver said, although it's convenient to describe the plaintiff in such a case as a secondary victim, that description must not be permitted to obscure the absolute essentiality of establishing a duty owed by the defendant directly to him. A duty which depends not only upon reasonable foreseeability of the damage of the type that's in fact occurred to the particular plaintiff, but also upon the proximity or directness of the relationship between the plaintiff and the defendant. And I think the next passage is really key because it tells us what we need to know about how this area of the law has developed. Lord Oliver said, the answer has, as it seems to me, to be found in the existence of a combination of circumstances from which the necessary degree of proximity between the plaintiff and the defendant can be deduced. And in the end, it has to be accepted that the concept of proximity is an artificial one which depends more upon the court's perception of what is the reasonable area for the imposition of liability than upon any logical process of analogical deduction. So I think there we have it. In black and white, proximity and the control mechanisms which exist under its umbrella are artificial concepts used by the court to determine whether a case falls on one side of the line or the other. Page and Smith was a fork in the road because here we had a case in which the claimant had a minor car accident. He suffered from ME. He had no physical injury, but he suffered a recrudescence of his ME. The Court of Appeal overturned Mr. Justice Otten's decision that the claimant should succeed, saying that the injuries were not reasonably foreseeable. 3-2, the House of Lords overturned the Court of Appeal's decision, mentioning that it was essential in these cases to distinguish between primary and secondary victims. And if it's a primary victim, then the control mechanisms have no role. So in other words, the court taking up and using the difference between primary and secondary victims that was articulated by Lord Oliver and Alcock. I've just put in the slide, we put in the slide as a note, Lord Gough in white thought that Page had been wrongly decided. I think that's for interest only. Lord Gough thought that even for primary victims there was a need for foreseeability of psychiatric injury. That is no longer the case. So now we've seen, can we have the next slide please, Laura? Now we've seen how these control mechanisms developed and really why. We think for practical reasons to try to put the brakes on the class of people who would otherwise be able to claim in these circumstances. So in most cases, we'll have a look at how it's applied in a moment, but in most cases the distinction is reasonably obvious. There will be a number of cases on the margins. Young and Charles Church is an example. A scaffolder gave a scaffolding pole to his colleague, who then inadvertently touched a live electricity wire with the scaffolding pole and was electrocuted and died. You might think that the scaffolder who saw this was a secondary victim, but in fact the decision was that he was a participant and he was so close to the events that he was effectively a primary victim. So in certain circumstances you can see that the facts will allow a case to fall one side of the line rather than the other. Just a brief diversion in relation to rescuers. I'm just going to mention White and the Chief Constable of Yorkshire, which by now is the 5th House of Lords case, 1999. Claims brought by police officers who attended at Hillsborough for psychiatric injury. Now, even though they were employees, the House of Lords held that the same restrictions should apply to their claims for psychiatric injury as to others. Now, this is essentially, it seems to us, a policy decision. And it's based on the fact that the relatives of the deceased could not succeed in Alcock. So how could it possibly be fair that the police officers should succeed in White? It's important because rescuers are a sort of hybrid version of primary and secondary victims. If they are not exposed to danger themselves, and we're talking, when we talk about rescuers, of those who go to the rescue of people who've been severely injured in absence, or reasonably believe themselves to be in danger, then they are to be treated as secondary victims. If, on the other hand, they are, or do feel as though they're immediately exposed to danger when they go to the rescue, then, as I understand it, they would be treated as primary victims. All of which brings us to a particular complication that has arisen in a number of recent High Court decisions, which we're calling the birth injury cases. So if we could just have the next slide. Please, Laura. Now, a number of you will be familiar with these types of case. Essentially, they have dealt with the question of whether or not a mother whose baby is injured in utero is to be treated as a primary victim, as she and her baby are one and the same person when the injury is sustained. Now, in one sense, it seems to us to be easy to state and easy and obvious to identify. But even though you may think that in circumstances where this occurs, a baby is injured in utero, then a mother is obviously a primary victim, we do not think that is necessarily an end to the inquiry as to whether or not she can recover damages for psychiatric injury. There may be different causes of her psychiatric injury. And remember, it's all about the artificial concept of proximity, per Lord Oliver in Alcock. And we think that there are likely to be future cases in which the courts will still have to decide, even though the injury was sustained in utero, whether or not a mother actually needs to satisfy the secondary victim control mechanisms, even though that is the case. A very quick tour through these cases. Farrell and Merton, judgment of Dame Lizabeth Steele, it is a very difficult judgment to follow. It's a birth injury case. It included, the injury was caused by the trauma of the birth, caesarean section, the first sight of the injured child, and conversations with the doctor. The claimant was treated as a primary victim. She also claimed for back injury in having to pick up and carry around her severely injured daughter. But the judge held that was not part of the trauma of the birth, and so no damages were awarded. But general damages included an element for the loss of private life as a result of having to care for the disabled child, which suggests that there is some connection established by the fact that the mother is a primary victim between the injury she sustained and then having to look after a disabled child later. It's a difficult case to understand and to follow, and I do not recommend it as a case to turn to if you're looking for clear articulations of principle in this field. The next case is Wilde and Southend, a death in utero caused by negligence, the failure to note abnormal intrauterine growth rate. Death was diagnosed in utero, after which there was induction of labour and a stillborn son. The defendant admitted the mother's claim for psychiatric injuries and settled it, accepting she was a primary victim. The father's claim was dismissed. The case of Taylor and Novo was relied on, and Laura will be dealing with that later. The husband was not present when the negligence actually occurred. He was only there for the manifestation of it. But also the claim failed on the basis that it was not a shocking, sudden event. I put the case here for this ingenious argument. The defendant argued that as the baby was the primary victim, the father could not be a secondary victim because the baby had never existed. The primary versus secondary victim argument was used by the claimant and accepted by the judge. So for these purposes, mother and son were regarded as one person, and the father could be a secondary victim even though the injury, physical injury, was to the baby. Wells and University Hospital NHS Foundation Trust, Dingemans, Jane Adderall, Justice Dingemans. A baby died 35 minutes after birth as a result of aspiring meconium during labour. The defendant was not negligent. The judge dealt with the claims for psychiatric injury by both parents anyway. He said that in his judgment, Mrs. Wells was a primary victim. This is because the negligence, if it had been established, would have occurred when Layla and Mrs. Wells were still one. In that sense, the judge held that the claimant, had there been negligence, would have been entitled to recover for her own psychiatric injury. But one confusing factor in the judgment is that the judge said that there was a lack of evidence which made it difficult for him to determine whether or not the mother's psychiatric injury was caused by shock. That, it seems to us, was an unnecessary problem for the judge to identify, because once a primary victim, there doesn't appear to have to be an element of shock. Ari and Calderdale is an example of a mother and grandmother both successfully suing for damages for psychiatric injury in the circumstances of a traumatic birth, and I'll say nothing more about it at the moment. YAH and Medway was a case in which baby suffered brain injuries at birth and mother claimed damages for psychiatric injury. A number of factors contributed to her psychiatric illness: the birth, its aftermath, both immediate and long term, and the stress and strain of caring for a disabled child. The judge, Mrs. Justice Whipple, who was the unsuccessful counsel for the claimant in Wilde, awarded damages to the claimant. And this is the key point about this case: the traumatic nature of the birth made a material contribution to the entire injury, which was indivisible. Although the claimant pleaded and relied on shock as causing the injury, ultimately the case turned on the evidence that the traumatic birth made a material contribution, and that really depended on the evidence. I will say nothing about calling an expert who admits in the box that she never reads the medical records, even though she says that she has in her report, because she's too busy. Save to say that my own shock and horror felt pretty much like early onset PTSD at the time. So Zoromska Smith is another example of mother as a primary victim in utero injuries. So finally, on this topic, could we just have the next slide before I hand over to Laura? So primary and secondary victims. What conclusions can we draw from these birth injury cases? Well, the YAH conclusion: if traumatic birth or sight of severely injured child in immediate aftermath causes or makes a material contribution to an indivisible, I would insert in their psychiatric injury, the mother can recover damages for all of her loss. Potential problems: late onset depression caused by looking after a severely injured child. I'm going to add another one. What if a baby seems fine, but develops symptoms as a result of negligently caused in utero injuries weeks or months or years later, and these cause psychiatric injury to the mother? Is the mother a primary or secondary victim? Now, I'm not certain that any of us could give you a sensible answer as to how the courts would deal with either of these two hypothetical situations. But if we remember Lord Oliver and the artificial concept of proximity, and that both Lord Ackner and Lord Oliver stressed in Alcock that looking after an injured primary victim is not sufficient to found sufficient proximity and a claim for damages for psychiatric injury, I think one may instinctively feel, perhaps I speak only for myself, that these would be treated as secondary victim cases. So I think we can see that defining the mother as a primary victim does not necessarily answer all the questions that may arise. As for secondary victims, the situation is, I think, reasonably clear. So partners and other family members present at a traumatic birth will have to satisfy the various control mechanisms. I think there could be difficulties if a father is, as in the Wilde case, not actually present when the negligence occurs and sees only the first manifestation of it. But I think Laura will probably be dealing with that in slightly more detail when she looks at her section. So I hope that's a helpful look at the history and where we are with primary and secondary victims now, and we're now going to look at what that actually means in terms of practice. And so Laura, over to you.
Thanks, Ed. I hope everybody can hear me all right. It's very strange not being able to see you all. Any issues, do please let us know on the chat function. So I'm going to deal very briefly with an important control mechanism, which is that of proving close ties of love and affection. There are two types of relationship where the close tie is presumed, that of parent and child and that of husband and wife, although that presumption is rebuttable. So if there is evidence to suggest some sort of serious conflict or estrangement, for example, in medical or social services records, then there may be an issue over whether this control is satisfied even in these categories of relationship. It's important to remember in other cases of family relationship or friendship, then the close tie of love and affection must be proved. And of course, this includes siblings, which is one of the areas where I think parents will need to establish the nature of their relationship, usually done by way of witness evidence. And it's important to bear in mind the high hurdle that that evidence needs to reach. It's not enough simply to establish that there is a friendship or that adult siblings remain in touch. you'll see, as I set out here, that the hurdle is there can well be relatives and friends whose relationship is so close and intimate that their love and affection for the victim is comparable to that of the normal parent, spouse or child of the victim, and should for the purpose of this cause of action be so treated. One other topic I wanted to deal with while looking at close ties of love and affection as a control mechanism is that of bystanders, because in the case of Alcock, Lord Ackner apparently left open the possibility of a claim by a bystander if the circumstances were sufficiently shocking. And the example that he gave in that case was of a circumstance such as a petrol tanker colliding with a school. The door to this, though, was closed by the Court of Appeal. I just had a message saying that somebody's lost me. Can people still see and hear me? Ed, can you still see and hear me?
Yes, but you did, in Nick Bowen's words, you did begin to sound a little bit like a Dalek from time to time.
Sorry, it's the challenges of rural living. You'll have to forgive me. Yes, I was just dealing with the possibility left open by Lord Ackner of a claim by a bystander if the circumstances were sufficiently shocking. And the door to this was closed by the Court of Appeal in the case of McFarlane and EE Caledonia Limited, which is a case arising out of the Piper Alpha disaster. It occurred to me alarmingly when I realised this that some of you probably are too young to know what that was. It was a disaster in 1988. Piper Alpha was an oil rig off the coast of Scotland. And there was a series of explosions and the rig was engulfed in flames, tragically ending in the death of 167 workers. The claimant was on the oil rig normally, he worked there, but on the night in question was on board a support vessel nearby, and he brought a claim for nervous shock. There were a number of difficulties with the claim, but for the purposes of this talk, the important part of the judgment is simply this section from Lord Justice Stuart Smith, where he said, in my judgment, both as a matter of principle and policy, the court should not extend the duty to those who are mere bystanders or witnesses of horrific events unless there is a sufficient degree of proximity which requires both nearness in time and place and a close relationship of love and affection between plaintiff and victim. Ed, I'll hand back to you for this section.
Thank you, Laura. So the next control mechanism we're going to look at, and I'm really going to take this very quickly, is the fact that the event has to be shocking and horrifying. It has to be objectively so. You can see the definition by Lord Ackner in Alcock, and I've called it objective. Shocking and horrifying is judged by persons of ordinary susceptibility. We can have the next slide. I'm going to spend hardly any time on this. All of those cases can be read and easily understood. They are all cases in which the high bar that is required to prove a shocking and horrifying event was not reached, and they are all cases that occurred in hospitals. I'm going to make 2 points about these cases. The first is to quote from Lord Justice Tomlinson in the Ronayne case, which is the second case on our list. He said this: in hospital, one must expect to see patients connected to machines and drips, and expect to see things that one may not like to see. A visitor to a hospital is necessarily, to a certain degree, conditioned as to what to expect, and in the ordinary way, it is also likely that due warning will be given by medical staff of an impending encounter, likely to prove more than ordinarily distressing. So that's one point. It is a high bar. It's a particularly high bar in hospitals. His Honour Judge Hawksworth in the Ward case said that you needed something exceptional in a hospital, which is not to say that it can't happen, but it rarely happens on these authorities. The only other point I was going to make is this. In Ronayne, the judge, who was Alan Gore, rather dismissed the diagnosis of psychiatric illness, saying it didn't really matter whether it was an adjustment disorder or whether it was PTSD. As far as he was concerned, the claimant had a psychiatric illness, and that was good enough. The Court of Appeal said no. The taxonomy, as they call it, of these diagnoses in the psychiatric field are important because they can give you a clue as to whether or not, in fact, the control mechanisms that require the sudden appreciation of a shocking and horrifying event are established. So in that sense, one would imagine that a diagnosis of PTSD would be more likely to satisfy that control mechanism than a diagnosis of adjustment disorder or depression. But that said, In the owner's case, there was a diagnosis of PTSD, and even in that case, that was not sufficient to establish liability. So that is all I'm going to say about the shocking and horrifying control mechanism, and I will hand back to Laura.
Right, this takes me to the control mechanism of proximity in time and space. I don't shy away from saying that this is one of the most vexed aspects of what is already a very difficult area of law. I'll try and impose some sense on it, but I think for the reasons that others described of the natural progression of this area of law, imposing sense on it is not always easy. So proximity is used in two different senses, and it's important to bear that in mind. The first is the broad legal sense that we learn when we first learn the law of tort, the neighbour principle that describes the relationship between parties that is necessary in order to found a duty of care. Proximity, when it's used in the context of secondary victims, though, is a reference to the narrower control mechanism requiring the person who asserts the duty of care to be in physical proximity in time and space to an event, whatever that event might be. And it's the latter of these that we're concerned with in this talk. On the face of it, the requirement that the person be proximate to the event appears straightforward. And in many cases it is. The classic example would be the secondary victim witnessing a car accident in which their loved one is injured. It's always the case with the law, though, that just when you think it's clear, factual scenarios arise that don't easily fit the test. So what happens in cases where the facts are not those of a conventional accident? This is an issue the court has had to grapple with. What is the event that the potential secondary victim must be proximate to? And examples of situations that have caused difficulty are a drawn-out event that takes place over hours, where there's an initial minor accident and a later major physical event, and where there is a gap in time between the breach of duty and the onset or appearance of the injury. So, turning to the cases that I want to talk about, there are quite a number of cases that touch upon these difficulties, and time doesn't permit me to review all of them. What I am going to do is look at 4 of the key cases. And the first case to grapple with one of these difficulties is the 1993 first instance decision by Mr. Justice Wilde in the case of Taylor and Somerset Health Authority. To understand this decision and later authorities that consider it, it is necessary to look at its facts. The deceased suffered a heart attack at work and died. The case tells the reader nothing about the circumstances of the heart attack, except that it was the final consequence of the deceased's progressively deteriorating heart condition, which the health authority, by its negligence many months before, had failed to arrest. The important explanation for this lack of information about the heart attack is that it was not witnessed by the proposed secondary victim, the deceased's wife. She was told the news of the heart attack by telephone. She attended the hospital where she was told that her husband had died, and she visited and saw her husband in the mortuary. So for those of you who have some familiarity with this area, this is what would be described as an immediate aftermath exception case, one where the secondary victim did not witness the event at all, but only its aftermath. In his judgment, Justice Olds said this, and it's an important passage that's been relied upon in other cases, including the recent case, the secondary victim exception, that is. Cautiously introduced and cautiously continued by the House of Lords, they are of 1, an external traumatic event caused by the defendant's breach of duty, which immediately causes some person injury or death, and 2, a perception by the plaintiff of the event as it happens, normally by his presence at the scene or exposure to the scene and or to the primary victim so shortly afterwards that the shock of the event as well as of its consequences brought home to him. There was no such event here other than the final consequence of Mr. Taylor's progressively deteriorating heart condition, which the health authority by its negligence many months before had failed to arrest. In my judgment, his death at work and the subsequent transference of his body to the hospital where Mrs. Taylor was informed of what had happened and where she saw the body do. Amazingly, Mrs. Taylor's case failed. She hadn't witnessed an event at all, neither the heart attack nor its immediate aftermath. The next case to consider is that of North Glamorgan NHS Trust and Walters. It's a case about what amounts to a shocking and horrifying event, and like all of these cases, it was very sad. The important facts for the argument about proximity were these. The claimant's baby was admitted to hospital in June 1996 with jaundice. The baby was misdiagnosed. With a proper diagnosis, he should have undergone a liver transplant, and he probably would have lived. Some weeks after the misdiagnosis, on the weekend of the 26th of July, the parents returned him to hospital unwell. On the morning of the 30th of July, the mother awoke to find the child fitting. 36 hours later, he died. The question the Court of Appeal had to consider was whether the identified event, which started with the fit on the 30th of July 1996 and concluded with the child's death 36 hours later, could fulfil proximity for the purposes of the Olcott criteria. This is what Lord Justice Ward said about the meaning of an event. Lord, permit a realistic view being taken from case to case of what constitutes the necessary event. Our task is not to construe the word as if it had appeared in legislation, but to get from the various authorities. As a word, it has a wide meaning as shown by its definition in the dictionary as an item in a sports programme or the sports programme as a whole. It is a useful metaphor, or at least a convenient description for the fact and consequence of the defendant's negligence, per Lord Wilberforce, or the series of events which make up the entire event, beginning with the negligent infliction of damage through to the conclusion of the immediate aftermath, whenever that might be. It is a matter of judgment from case to case, depending on the facts and circumstances of each case. Ultimately, the court concluded that the period from fit to death satisfied the Olcott criteria. Lord Justice Ward said that there was an inability of the hospital properly to diagnose and then to treat the baby, the fit causing the brain damage which shortly thereafter made termination of this child's life inevitable, and the dreadful climax when the child died in her arms. It is a seamless tale with an obvious beginning and an equally obvious end. It was played out over 36 hours, which for her, both at the time and as subsequently recollected, was undoubtedly one drawn-out experience. For the purposes of the case of Poole, which I'll come to in a moment, it's significant in Walters that the event started some weeks after the misdiagnosis and also some days after the child returned to hospital with worsened symptoms. The third case I want to consider before we turn to Poole is the personal injury case of Taylor and De Novo. This is a case where the claimant's mother was injured in an accident at work when some racking collapsed and fell on her, causing minor injury. 3 weeks later, the claimant's mother collapsed and died, an event that the claimant witnessed. At first instance, the judge accepted that the mother's collapse and death could be the relevant event for the purposes of the Olcott criteria, but the Court of Appeal overturned that decision, deciding that the relevant event was the initial accident and injury. I'm going to read to you something that I haven't set out on slide for purposes of space more than anything, but Lord Dyson said this from paragraph 28. I accept that the correct question is whether Miss Taylor and Novo were in a relationship of proximity in the legal sense. The difficulty in answering this question is that, as Lord Oliver said, the concept of proximity depends more on the court's perception of what is the reasonable area for the imposition of liability than any process of logic. In the context of claims by secondary victims, the control mechanisms are the judicial response to how this area should be defined. This has involved the drawing of boundaries which have been criticised as arbitrary and unfair, but this is what the courts have done in an area where they have had to fix the ambit of liability without any guiding principle except Lord Atkin's famous but elusive test. In the presence of Novo's negligence, in the present case, Novo's negligence had two consequences which were separated by 3 weeks in time. The judge described them as two distinct events. The use of the word event has the tendency to distract. In reality, there was a single accident or event, the falling of the stack of racking boards, which had two consequences. The first was the injuries to Mrs. Taylor's head and arm, and the second 3 weeks later was her death. There was clearly a relationship of legal proximity between Nova and Miss Taylor. Moreover, if Miss Taylor had been in physical proximity to her mother at the time of the accident and had suffered shock and psychiatric illness as a result of seeing the accident and the injuries sustained by her mother, she would have qualified as a secondary victim on established principles. But in my view, to allow Miss Taylor to recover as a secondary victim on the facts of the present case would be to go too far. And then at paragraph 32, Lord Justice Dyson set out this passage, which has been relied upon by defendants in subsequent cases. It follows that, in my view, the judge was wrong to hold that the death of Mrs. Taylor was the relevant event for the purposes of deciding the proximity question. A paradigm example of the kind of case in which a claimant can recover damages as a secondary victim is one involving an accident, which one, more or less immediately causes injury or death to a primary victim, and two, is witnessed by the claimant. In such a case, the relevant event is the accident. It is not a later consequence of the accident. Old J put the point well in Taylor and Somerset, and the references to the passage that I set out on the earlier slide. Miss Taylor would have been able to recover damages as a secondary victim if she had suffered psychiatric illness as a result of seeing her mother's accident. She cannot recover damages for the shock and illness that she suffered as a result of seeing her mother's death 3 weeks after the accident. So this takes me to the decision that provoked the idea for this webinar, which is the recent case of Poole and the Royal Wolverhampton NHS Trust. It was a strikeout application. It's the first strikeout application I think I've been on the receiving end of in my almost 20 years in practice. It was heard by Master Cook in late 2019, and Master Cook struck out the secondary victim components of the case. The matter then went on appeal before Mr. Justice Chamberlain in May 2020. It's necessary to look at the facts to understand the issues in the case. Mr. Poole attended hospital with cardiac symptoms in November 2012. On the 26th of January 2014, he was out shopping with his two young daughters, who were 9 and 12 at the time, when he collapsed in the street and died following a heart attack. It being a strikeout application, the matter had to be determined on the assumption that we'll prove the pleaded case, and the pleaded case was this: that there was a negligent failure to diagnose and treat coronary artery disease in 2012. With competent care, the heart attack 14.5 months later would not have occurred. The heart attack was the first point at which the damage occurred, or the damage became manifest or evident, and the circumstances were shocking and horrifying and caused both children psychiatric harm. The defendant's arguments were complex and technical, and I don't want to do any disservice to the nuanced nature of them by reducing them to 2 bullet points, but I'm going to give it a go. In a nutshell, they were these. In this case, there was no event for the purposes of the attack, was simply the final consequence of his progressively deteriorating heart condition, which the health authority, by its negligence many months before, had failed to arrest. You'll recognise that from the case of Taylor and Somerset. And the defendant argued that in this regard, the case was indistinguishable from Taylor and Somerset, which was authority for the proposition that an internal event of this sort can never satisfy the Olcott criteria. In the alternative, it was argued that if there was an event, the event occurred in November 2012, when Mr. Poole was negligently treated. It was argued by the defendant, upon the Johnson case, that the tort was completed at that point and the claimants did not witness it. Mr. Justice Chamberlain's judgment is detailed and thoughtful. I would say that he found in my favour, but I think objectively it's a fair observation. He reviews all of the relevant case law, and indeed Ed and I have done a fairly detailed briefing that you can find following that link. I'm not able to go into the detail of the case in the same way in this webinar, just because of the circumstances of time. Mr. Justice Chamberlain identified the key question as being whether Mr. Poole's collapse from a heart attack 14.5 months after the allegedly negligent treatment is capable of constituting a relevant event. He identified 3 possible reasons why it might be argued that it would not. The first was this: the argument that the event has to be synchronous or approximately synchronous with the negligence which gives rise to it. This was not argued by the defendant, and Mr. Justice Chamberlain observed that the defendant was correct not to. saying that the reason why they were correct not to is relevant to the arguments that they did advance. Although McLaughlin and Alcock were both cases where the negligence was close in time to the event, there is nothing in any of the House of Lords authorities to suggest that this must invariably be so. Lord Oliver said in Alcock that the temporal propinquity required was between the psychiatric injury and the event caused by the defendant's breach of duty to the primary victim, not the breach of duty itself. Secondly, a possible reason why not was that the argument that the liability should depend on there being a negligent act rather than an omission. Again, this was not argued by the defendant, and Mr. Justice Chamberlain said they were right not to do so. He said there was no reason in principle why an omission should be treated any differently, and observed that Walters was a case of negligent omission. The third possible reason was this, that the claimants were absent from the scene of the tort, and this was very much part of the defendant's submission. Mr. Justice Chamberlain said, though, that in my judgment it takes matters no further. In accident cases like McLaughlin, Alcott and Taylor and A. Novo, where the breach of duty and the damage caused are coincident in time and place, the scene of the tort is also the scene of the negligence. When the negligence and damage are separated, and assuming that there is no requirement for the negligence and damage to be synchronous, the scene of the tort can only mean the scene where the damage first occurred. In the tort of negligence, this is the point where the tort has become actionable or complete. Having accepted this proposition, Mr. Justice Chamberlain went on to accept that he had to proceed on the factual basis most favourable to the claimants, that the scene of the tort was the pavement where on the 26th of January 2014, Mr. Poole collapsed. So I've given you there a summary of the conclusions on this. Although McLaughlin and Alcott were both cases where the negligence was close in time to the event, there is nothing in the authorities to suggest that this must be so. There is no requirement that the negligence and the damage be synchronous. And the arguments about whether damage was sustained in November 2012 were contrary to the claimant's pleaded case and were triable issues of fact. Mr. Justice Chamberlain went on to consider the other part of the defendant's argument, which was that there was no event at all. And this was an argument essentially that the effect of Taylor and Somerset, approved by Taylor and A. Novo, was the heart attack could never amount to an event for the purposes of the Olcott criteria, being an event that was internal to the primary victim. And Mr. Justice Chamberlain rejected these arguments and set out these responses to a number of the defendant's detailed submissions. It was foreseeable that a negligent failure to diagnose and treat a heart condition could result in a sudden shocking event that might cause psychiatric damage if witnessed by close family members. There was no requirement that the secondary victim must perceive not only the injury, but also that it was caused by the defendant's negligence. Taylor and Somerset was not authority for the proposition that the event had to be external to the primary victim, but it was authority for the proposition that it had to be external to the secondary victim. And a contrary conclusion would mean that Walters was wrongly decided because, of course, Walters involved an event to the baby that was internal to him, but external to his secondary victim mother. And the ratio of Taylor and A. Novo is that in a case where the defendant's negligence results in an event giving rise to injury in a primary victim, that event cannot be a subsequent discrete event. Now, I've set out on these two following slides the conclusion, the reasoning of the conclusion in some detail, but I'm conscious that we're running short of time. What I wanted to deal with is an interesting point that Mr. Justice Chamberlain dealt with thereafter. So those points were sufficient for the appeal to succeed, but he went on to consider an alternative argument that was advanced on behalf of the claimant, which I know from the questions we've received is one of interest to a number of you, and it's possibly, some might say, the most interesting part of the case. We did not accept in the course of argument that if, in fact, when the evidence is finalised, it transpires that Mr. Poole suffered some actual injury prior to his heart attack, that this would preclude recovery. Why? Well, in Walters, we knew that the child had been unwell for several weeks following the negligence, and he got worse in the days before his death. The fit that was started the event for the purposes of that case started several days after his readmission. And in respect of this issue, Mr. Justice Chamberlain said that Taylor and A. Novo would preclude liability in the present case if there were a relevant event prior to Mr. Poole's collapse on the 26th of January 2014, so that the latter could be said to be separate from it. In that case, Mr. Poole's collapse would be like Mrs. Taylor's, merely the consequence of the event caused by the defendant's negligence and not the event itself. In Taylor and A. Novo, however, there was something that could properly be described as an event prior to that witnessed by the secondary victim, the collapse of the racking boards onto Mrs. Taylor, the primary victim. That event coincided with or immediately preceded the moment when actual damage was first suffered by her, which was also the moment when that damage became manifest. The same will be true in most accident cases, but in the present case, there was nothing that could naturally be described as an event before Mr. Poole's collapse on the 26th of January 2014, even on the assumption that some actual damage was suffered before that date. The Court of Appeal in Taylor and A. Novo did not need to and did not decide whether a defendant could be liable to a secondary victim in such a case. It did not say, for example, that an event can only qualify if it coincides with or immediately precedes the first actual damage to the primary victim. So that led him to this conclusion. Forgive me, the previous, yes, sorry, I lost my slides. It's an important part of his decision that, and it's one that will be of very interest, particularly to claimant practitioners, but also to defendants, that in order to, at the moment, succeed on having an arguable case, and I put it no higher than that, it isn't necessary for a claimant to prove that the point of the event is the point when the damage first occurs, just the point at which it first becomes evident. And the other paragraph in Poole that I wanted to draw to your attention is this one. In terms of the approach of the courts, it's of interest because it's a comment that's been made in an area where the tenor of a number of the preceding reported decisions is conservative and restrictive. But Mrs. Justice Chamberlain said this: there is no reason to favour a conservative posture in which liability is accepted only where it has already been found to exist on indistinguishable facts. There is nothing to inhibit the courts from aiming for maximal coherence in the principles which govern the circumstances in which the existing control mechanisms will be satisfied. In doing so, they are bound by the rules of precedence, but are otherwise unconstrained. I've said watch this space. It remains to be seen whether Poole will travel further, and if it does, whether the Court of Appeal will favour the view of the claimants or those of the defendants.
So I'm going to, oh no, sorry, that's still you, isn't it, Laura? Is that right? That's me, isn't it? Direct perception?
It's you, Ed.
I thought it was. Okay, well, we set ourselves quite a task to try and deal with the complexities of these sorts of claims in an hour, and we are about to fail. So apologies for that. I can see that we're losing a few people from the numbers of participants at the bottom of my screen. If you'll forgive us, I think we will try and carry on, if that's all right, and then we will try and deal with the questions we had already received at the end, which I think should take us about another 10 or 15 minutes. So forgive us, but we will bash on. So if you're still with us and you're still interested, please stay with us, and we'll get to the end of it as quickly as we can. So we're now back to the control mechanism that deals with the necessity for direct perception of the event itself or its immediate aftermath. The first point is sight and hearing. I think to state that one has to be within sight and hearing of an event is not difficult to state, but of course the television and radio broadcast situation came up in Alcock. Now, one thing that I do think is really interesting, and we had a question on this from Perry Hill at DWF, who I will name check for it because it is an interesting question, is whether or not the situation about direct perception and relaying of images on television or other media is going to need to be revisited. And I think the answer to that question is probably yes. If you remember, I read out before, Lord Ackner said in Alcock that one of the things that all the parties would have in their contemplation is that television companies, responsible television companies, would not show gruesome pictures of individuals. But of course, social media doesn't abide by those rules at all. I think, for example, of something like the death of George Floyd and whether or not a full unedited camera shot video of George Floyd dying at the hands of a police officer might, for example, be sufficiently horrific and shocking, and of course not subject to any television controls, such as the BBC not showing those sorts of gruesome images. So I think the answer is this may well have to be revisited, and we will await cases. Live streaming of events on Facebook, for example, as well, might be another topic that will be addressed by the courts. And if one of the main bars to such a claim was the fact that TV companies just don't show these sorts of images. Well, I think that bar would go. So it would be an interesting question as to which side of the line such a claim would now lie. On immediate aftermath, I'm going to be very quick. Just to let you know, McLaughlin was a case that succeeded, but it was said to be on the margins. That was when the claimant came upon the accident and injuries at hospital some 1 to 2 hours, I think maximum of 2 hours after the accident. So she was just within the immediate aftermath. But in Alcock, where a number of claimants came to visit the bodies of their loved ones 7 to 8 hours after the events, that was not the immediate aftermath. Those who wish to stretch the immediate aftermath as far as possible in order to found a claim are directed towards the case of Galley, Atkinson and Siegel. The claimant's daughter died in a road traffic accident. She arrived at the scene about an hour after the accident. She was told by a police officer that her daughter was dead. 2 hours later, she saw her daughter, deceased daughter, at the mortuary and cradled her in her arms. The judge in that case rejected the claim, said that there were no damages for being told of the death by the police constable. That's an echo back to the original cases from 1901. And that being at the mortuary 2 hours later was too late. And that was, I think, a total of 3 hours actually after the actual accident. But the Court of Appeal decided that the aftermath could be a number of events that provided sufficient proximity as long as there was a seamless tale sufficiently connected to the accident. They described it as an uninterrupted sequence of events of which the mortuary visit, which was the main causative element of the psychiatric damage, was a part. And it seems to us that this is just an example of the artificial concept of proximity being used to allow a claimant to succeed on essentially what are policy grounds. So I think we can move on to the next slide, Laura.
I just settled back into listening to you, Edward, and realised it was going to be back to me so quickly. So we have a section at the end of our talk dealing with causation, and you'll see here that I've said that causation in these cases can really amount to a talk in itself. And because we knew that there were other aspects that we wanted to focus on, I'm going to deal with what is nonetheless an important section quite briefly. If there are particular issues people would be interested in further webinars on in the future, then you are always welcome to contact us, because we're always very happy to have suggestions for us to consider. But in terms of causation, there are two essential elements. Firstly, that the claimant must suffer from a recognised psychiatric injury. In other words, not something short of that, such as grief or distress. And secondly, that recognised psychiatric injury must be caused by the sudden appreciation of the horrific event. And whenever one's dealing with a secondary victim claim, it's very easy to get blinded by the sheer volume of factors that you have to consider, taking into account issues over primary or secondary victim and all of the different control mechanisms. And in my experience, it's not uncommon for causation not to receive the focus that it needs. When you're dealing with your expert evidence, whether you're acting for the claimant or defendant, it doesn't make any difference. You need to be considering very carefully whether that evidence supports the argument that the cause of the psychiatric condition is the sudden appreciation of the horrific event. And the reason why I underline that is the fact that these claims normally arise in circumstances where there is a close tie of love and affection between the primary and secondary victim means that that secondary victim is living usually with the ongoing consequences of a serious injury to the primary victim. Whether it's a birth case and you've got a claim by a mother in those circumstances, primary victim, or whether you're dealing with something like, for example, a sibling witnessing a serious accident to its other sibling and has been growing up in a household with a sibling that suffers from consequences of brain injury or serious physical deficit. Now, the cause of the psychiatric injury has to be the appreciation of the event and not the things that happen thereafter. And it's important that you bear that in mind when you're considering your evidence. The caveat that I put down there is the case of Farrell and Merton. Ed's already expressed his views about that case to you. But that is a case where amongst a number of issues that was considered by the judge, she considered an argument by the defendant that actually the cause of the psychiatric condition to the mother was the dawning realization of the injury to the child, and not the event that caused the injury in the first place. And the judge in those circumstances essentially accepted that the two were a sort of indivisible, connected combination of events. It's not the best quality decision, and so I think one has to approach those arguments with care and with some caution. Ed, I'll hand back to you.
So now we're into effectively what is a branch of causation. I mean, it's the question of apportionment of damages. And this really all depends on whether or not a psychiatric injury can properly be described as divisible or indivisible. The principle was first enunciated in Barber and Somerset and related cases by Lady, later of course Baroness Hale. And the idea was that if, in a stress at work case as that was, you had a claimant who had a number of other factors which could be causative to a psychiatric illness, then there might be two circumstances in which you would reduce the damage. One, if you could actually attribute a part of the psychiatric injury to other factors, the defendant should not pay for that. And two, if in fact somebody had predisposing factors, would they, as a matter of hypothetical fact in the future, have suffered a psychiatric illness in any event? In Dickens in 2002, Lord Justice Sedley and Dame Janet Smith said that once you've actually made a decision that a negligent act or omission made a material contribution to a psychiatric illness, well, really all psychiatric injuries were indivisible, and therefore the claimant should recover in full. But in BAE and Consac in 2017, the Court of Appeal said, no, that's not right. It's not right to say that all psychiatric injuries are, as it were, necessarily indivisible. Some of them may be. And what the Court of Appeal said in the Consac case was, to the extent that there was a difference between the views expressed in the two cases, that's Barber and Dickens, Barber should be followed. In conducting the apportionment exercise, the question was whether the tribunal could identify, however broadly, a particular part of the suffering which was due to the wrong, not whether it could assess the degree to which the wrong caused the harm. Barber explained, Dickens doubted. So it may be possible to separate out, for example, symptoms caused by PTSD as a result of witnessing an accident from depression caused by other factors. And this in turn, as I've said in the slide, may depend on whether the injury is divisible. If you remember the YAH and Medway case that we looked at before, Mrs. Justice Whipple determined on the evidence that the traumatic circumstances of the birth made a material contribution to all of the claimant mother's psychiatric injury, which was indivisible. And in those circumstances, that appears to me to be uncontroversial. If, on the other hand, the injury had been divisible and there was a separate part of it on the evidence that could be attributed to, for example, depression arising at a later stage in her life as a result of looking after a disabled child, then it might be possible to separate that out and reduce the damages accordingly. So, next. So here we are at the last word. Lord Hoffman in white. It seems to me that in this area of the law, the search for principle was called off in Alcock. No one could pretend that the existing law is founded upon principle. It's too late to go back on the control mechanisms. Until there is legislative change, the courts must live with them and any judicial developments must take them into account. And I'm just going to translate that for you as best I can. I think what he means is, this is all very difficult. It may well be wrong. Judges have been making it up as they go along. Can we have some help from Parliament, please? Good luck, everyone. If you're still with us, why don't we look at some of the questions that were submitted to us before this talk? And we'll do that reasonably briefly. And as I said at the start, if there are any other questions that have arisen under the Q&A tab that we've got on our Zoom screens, we will deal with those separately at a later point. So question one from John Thompson at DWF. Can you envisage a scenario where a secondary victim could bring a claim for breach of Article 3 and or Article 8 of the Human Rights Act? Very briefly, I'll answer that. I think the answer is yes. We already have the concept of direct and indirect victims for the purposes of claims under the Human Rights Act. And indirect victims are essentially what we would describe in the common law context as secondary victims. There's quite a lot of Strasbourg case law about it, but if you want a quick, easy reference to a case that deals with victim status, both of direct and indirect victims, looks at the cases, looks at the guidance that's been issued by the European Court of Human Rights, go to the case of Daniel against St George's Healthcare, 2016, 4 weekly law reports, 32. Next question from Philip Davis. Parent, secondary victim, child accident, child lives, short period, life support turned off. It's a very perfunctory question, but I think we get the sense of what the question points to. And I'm afraid I would simply answer that question by saying, well, it depends. If the parent could satisfy the control mechanisms for secondary victims that we've been through in our talk, then there's no reason why that claim should not succeed. But remember that in hospitals, shocking and horrifying has to be exceptional. And the next question was from Perry Hill, and I've already referenced it and name-checked him. He said, will technological advance mean that the law on proximity requires updating? I think the answer is, it may well do. Laura, would you agree with that?
I think, yes. It's difficult, isn't it? Because you can see arguments for an incremental step that makes sense, but then it opens up a whole new potential floodgates that I suspect the courts may be reluctant to do so. So I think possibly. Yeah,
but as I said before, I don't think the objection to television coverage that was relied substantially on in Olcott by Lord Ackner would now hold. There's no, social media is its own beast.
It's difficult to see why a parent who sees a dreadful thing happen to their child being live streamed on Facebook is in a particularly different situation to a parent who's standing there watching it. But then I suppose the court's concern is what happens about subsequent viewings of a recording and so forth. They're very difficult issues.
Yeah. The next question from Anonymous. How does this judgment, and I think that question obviously refers to Paul, so I'm just about to hand this question off to Laura. How does this judgment apply to cases where there has been some minor external manifestation of the damage, for example, a cough, prior to the sudden death? Will the tort have completed as soon as the cough develops? Would your answer differ if the minor symptom was present both pre and post the negligence? Good luck with that one, Laura.
I'm going to fall back on the barrister's favourite answer if it's fact specific. Ultimately, it depends whether it's a Walters situation or a Taylor and a Novo situation. The judge in Poole accepted that if there is something that can be classed as being an event that occurs prior to the shocking, horrifying incident consequence that you're concerned with, then under Taylor and a Novo, that may well be a bar. But we also know that in Walters, the child was presenting with symptoms before the start of for a period of time, quite a protracted period of time before the point at which the fit started. It was the start of that horrifying, seamless tale. So it's fact specific, and it will require careful examination of whether it's a Taylor scenario or whether you can argue that it remains within Walters.
But if the judge, if Mr. Justice Chamberlain is right, in saying that it doesn't really matter whether the cause of action accrued way in the past, if the first manifestation it is a shocking event rather than a sort of grumbling event as it was in Walters, then if that's right, then, I mean, if one assumes that this cough is just a minor symptom, one might expect to succeed. Do you think that's right?
Or at least not get struck out.
Or at least not get struck out. The next question from Alice Webster at Owen Mitchell. What are the challenges in bringing a secondary victim claim in stillbirth cases where the negligence occurred in labour and father was present? Well, I think the simple answer to that is the challenge. We've been through the challenges. So see above, really. I think a lot of it would depend on causation. I think the major challenge would be, was there an event that was sufficiently shocking, and was there a sudden appreciation of it rather than a gradual onset of a problem developing? But there's no reason, it seems to me, in the right factual circumstances, why such a claim should not succeed. The next question from Conor Monaghan. How can Walters be distinguished from Taylor and Somerset? It seems to me this wasn't clearly answered in Poole. Thanks. Well, I think Laura has attempted to answer that. Well, I think she's very satisfactorily answered in her section on time and space.
I gave it a go.
So I think we're going to say that that question has been answered as best we can answer it. Kim Chamberlain from Novum Law. Son arrives at hospital 3.5, 4 hours post-accident, both parents seriously injured. He was warned before, but first there. So would such a claim succeed? I think probably not. It doesn't look to me like the immediate aftermath. And also there's the problem about having been told in advance what happened. And of course, the current state of the law is that just being told, and if that causes or contributes to a psychiatric illness, that would not be sufficient. And remember, McLaughlin and O'Brien was maximum of 2 hours, and that was on the cusp. But I've mentioned it already, you may get help if you need to try to extend what is meant by immediate aftermath from that case of Gally Atkinson.
And I guess it would also be fact specific in terms of what confronted him on his arrival.
Exactly. And then the final question we received, and the final one that we're going to deal with today, for those of us who are still with us, thank you very much indeed, from Helen Hammond at Pennington's. I'd be very interested to hear how counsel think the changes will affect secondary victim claims in stillbirth cases. Current thinking is that to be successful, dad, other family member needs to be present for both the negligent act as well as the shocking event, usually the birth, which is more likely if the negligence arises with labour management as opposed to pregnancy management. I'd be interested in hearing whether this position still stands, whether the manifestation of the negligence in pregnancy-related negligence is likely to be the death of the baby if this predates the stillbirth. Well, I think the question is based on an understanding of what the judge found, that was Michael Kent QC, in the Wilde and Southend case, where the first reason why the father's claim failed was because he wasn't actually present at the time of the negligence. The second reason being that it wasn't a sufficiently shocking event. I think it's possible that if Poole is to be where we are with the state of the law, and we don't know whether it's going to go to the Court of Appeal or not, but I gather from Laura that it may. But if that's right, then I think we may have moved on. If the stillbirth is the first manifestation and all the other control mechanisms are satisfied, then I think we may be able to say that things have moved on from Wilde and that a father doesn't actually have to be present at the moment that the negligence occurs. But I think that really depends on how Poole stands up to any further scrutiny.
And also whether or not what the father witnesses can meet the other aspects of the Olcott criteria, which is often the difficulty for those kinds of claims.
Thank you all very much indeed. As I said at the outset, we're not going to try and deal with the questions that have come in as we've been going along. We're going to deal with those separately. We've all got things to do. Thank you very much indeed for those who are still with us, for staying with us until the end.
Yes, it's wonderful to see so many people still there, actually. Thank you so much for bearing.
Thank you. Finally, I'm going to mention it again, because I was rather worried that I was going to forget to mention it at the end, and I've already mentioned it at the beginning, but I haven't forgotten to mention it at the end, so I'm going to mention it again. Next Thursday, 11 AM, same time, same place. Russell Wilcox, Conor Kennedy, discussing resulting trusts, constructive trusts, and Tolata claims. And for those of you who don't remember what a Tolata claim is, Trusts of Land and Appointment of Trustees Act 1996. So same time, same place, next week, next Thursday, 11 AM. Thank you all very much indeed. Thank you. Thank you, Laura.
Bye, everybody.